My obscure but phenomenal person in African American history is Christina Swarns. Christina Swarns is an attorney, a lifelong activist for criminal justice reform and death penalty abolition, a single mother, and the current executive director for the Innocence Project. In 2016, Ms. Swarns argued in front of the Supreme Court and won in the case of Buck v. Davis. I will be presenting that argument, in which she asserted that the introduction of racially biased evidence by the defendant's attorney disqualifies a death penalty verdict.
We'll hear argument next today in Case 15-8049, Buck v. Davis. Ms. Swarns?
Mr. Chief Justice, and may it please the Court. Dwayne Buck was condemned to death after his own court-appointed trial attorney knowingly introduced an expert opinion that his client was more likely to commit criminal acts of violence in the future because he is Black. Now, this evidence encouraged the sentencing jury to make its critical future dangerousness decision, which was a prerequisite for a death sentence and the central disputed issue at the time of sentencing, based not on the individual facts and circumstances of Mr. Buck's crime or his life history, but instead based on a false and pernicious group-based stereotype.
Didn't that expert say, I don't think he's going to be a future danger?
On cross-examination, Dr. Quijano testified that he did believe Mr. Buck was likely to commit future crimes of violence. He said that, at the prosecutor's questioning, that Mr. Buck was on the low end of the continuum, but that he could not say that Mr. Buck was not likely to commit criminal acts of violence. Here, this expert's evidence not only prejudiced Mr. Buck at sentencing, but it also put the very integrity of the courts at jeopardy. For that reason, Texas acknowledged that its ordinary interest and finality does not apply. It publicly declared that it would waive its procedural defenses and allow new sentencing hearings in 6 capital cases, including Mr. Buck's, that involved the same expert's race as criminal violence opinion. Now, Texas conceded error in 5 cases and then reversed course in Mr. Buck's case alone. As a result, Mr. Buck is the only Texas prisoner to face execution pursuant to a death sentence that Texas itself has acknowledged is compromised by racial bias and that undermines confidence in the criminal justice system.
There's a tension in your briefing over what you're really arguing for. In the question presented, you focus on the Fifth Circuit standard for a COA and saying they're imposing an improper and unduly burdensome. But most of the briefing, and as you've sort of begun today, is really focused on the underlying merits of the case. And you sort of have to make a choice, don't you? Because if we focus on the merits and rule in your favor, well, then we don't get to say too much about the threshold for certificate of appealability. Well, if we focus on the certificate of appealability, all we're saying on the merits is that there's a substantial showing. So what do you want us to do, on the merits or on the certificate of appealability?
Well, in order to determine whether Mr. Buck was entitled to a certificate of appealability, this court and the Fifth Circuit was required to determine whether or not the district decision with respect to both the constitutional question and the procedural question would be debatable among peers.
Right. So is that what you want us to say, that because the merits are debatable, he should have gotten a certificate of appealability? Or do you want us to say, well, he should have won, and so he obviously should have gotten a certificate of appealability?
We believe that the district court's decision was incorrect, and therefore Mr. Buck was entitled to a certificate of appealability. This court has long recognized that the integrity of the courts requires unceasing events to eradicate racial prejudice from our criminal justice system. The commitment is as urgent today as at any time in our nation's history. Dwayne Buck's case requires meaningful federal review of his claim that his trial counsel knowingly introduced an expert opinion that he was more likely to commit criminal acts of violence in the future. A certificate of appealability should certainly issue. With respect to Texas's arguments, I want to begin by making clear that this court in Georgia McCollum did make clear, as I think Justice Sotomayor noted, that the equal protection concerns that are implicated by the introduction of race into the criminal justice system absolutely are triggered by defense counsel's conduct. And certainly, that was a situation where defense counsel exercised preemptory challenges based on race. And in that circumstance, that was actually an exercise of preemptory challenges intended to benefit the client, correct? They were trying to strategically gain advantage by using a race-based preemptory challenge. But here, we have trial counsel making an inexplicable decision to introduce a knowing inexplicable decision to introduce race. When Texas did its review of death row cases after it conceded error in Saldana, it looked through all of the cases on death row to see what else was contaminated by Mr. Quijano's racist criminal violence opinion. And one of the other cases it looked at and ruled out was the Anthony Graves case, which demonstrates the options available to this prosecutor under these circumstances. In the Anthony Graves case, Dr. Quijano was called as a defense witness, just as he was here. In the Anthony Graves case, the defense elicited Dr. Quijano's race as criminal violence opinion on direct examination, just as here. But the difference is in the Graves case, the prosecutor did not reiterate it on direct examination, and then in closing, argued that the jury should disregard Dr. Quijano's opinion, which he did not do with Mr. Buck's case. The prosecutor here absolutely capitalized on trial counsel's error. There's just no question about that. They made a choice, and they could have gone the Graves route, but this prosecutor chose to go through the door that was opened by trial counsel and rely on Dr. Quijano's race as criminal violence opinion. Counsel for Texas also notes that the last note that the jury sent out was a request to review the crime scene video, which is absolutely true, but it means that the last two notes that the jury looked at, the last two things that they asked for was the criminal video and the expert's report. So now we have the race and we have the crime. This is exactly the circumstance that this court addressed in Turner, correct? You have the facts of the crime that triggered this racialized fear of violence and raised the real risk of an arbitrary death sentencing decision, and then you have the report, which compounds the risk because it gives the defense expert scientific imprimatur to the pernicious group-based stereotype. So that is further evidence to prejudice Mr. Buck. Last, I would just be clear that when Mr. Buck litigated his first 60B motion, Coleman, as Texas has acknowledged, stood as an unqualified bar. There was no opportunity before Ms. Martinez was announced for him to argue. Thank you.